So it says related to credit delivery. So first of all, we will be studying related to documentation, that what is documentation. So let me tell you that when you have done the appraisal of the borrower itself, that when you have sanctioned the loan amount, then further the documentation is to be done. The documentation is basically related to what? It is basically related to that whatsoever the documents, so as to create the primary security, so as to create the secondary security, so as to make the borrower obligated related to the liability. Documents are to be signed by the borrower itself and by the guarantor itself. Okay, so as the bank can basically establish the liability in the court of law. Okay, so that is the main process related to documentation, because those are signed, those are executed by the borrowers and the guarantors, so as to basically ascertain the liability of the borrower, and further that must be ascertained that the documents can be basically followed up in the court of law. Okay, so in addition to that, the borrower has to sign the documents which create the charge. I already told you that the aspect is related to, because we want to create a charge on the property, on the assets of the borrower over here. It may be the case that we want to create primary security or the collateral security. In that case, those can also be established only and only through the way of documentation. And further, if the owner of the collateral security is someone else, so let us take the case that we are basically extending a loan to person A over here, and the security so given, security so provided by the person A is not basically A is not having the ownership of the security and B is the owner of the security. In that case, either B will be the co-borrower or B will be the guarantor in the loan its case, or B will be guarantor in the loan case itself. That is related to what? That is related to documentation, that why documentation is required. But there are a few points that must be looked into. First of all the documents must be properly stamped. So whatsoever the documents are executed, those must be stamped properly as per the prevailing laws. And further, it must be clearly mentioned related to date of execution of the documents. Why date of execution is important? Because so as to ascertain the law of limitation, so as to ascertain the limitation period of the document itself. And further, it must also be ascertained that the stamping of the documents is done before, on the day, or before or on the day of execution of the document itself, but not after the execution of the documents. Okay, so the documents must be properly stamped, and the stamping is to be done before the execution of documents or on the day of the execution of the documents, but not after that. Okay, and also there, that must be a place must be mentioned over the document itself. So whatsoever the place where the documents have been executed, that must be mentioned on the document itself. But why place factor is important? Because it is basically so as to ascertain the jurisdiction. So if there is something, likewise, if a loan was sanctioned to person A and he is not repaying the loan, then in that case, if you want to basically start prosecution, in what court's prosecution, in what court's jurisdiction the case will be prosecuted. Okay, so in that case, the place will basically, the place where the documents have been executed, that will basically help us so as to ascertain the jurisdiction. Okay, so that is why the date and place both are very much important. And further, it should be ensured that the parties executing the documents have the necessary authority. So whatsoever the parties who are going to execute the documents, they must be having the capacity that they can do execute the documents, and further they must be having the authority. Likewise, the case is where you want to sanction a loan to the company, where the designated, where the authorized directors are D1 and D2. In that case, the documents must be executed by D1 and D2 only, and not by other any directors, because those are not authorized. So D1 and D2 must be having the authority so as to execute the documents, and further they must be having the capacity so as to execute the same. Then it is related to, it should be ensured that the person signing the documents is going so with his free will. It should not be the case that someone is basically there must be no pressure on some party related to execution of the document. So it must be done with the free will itself. And further, the documents should be filled in before those are signed. Okay, and further the documents, if the signatures of the executor are in other language than that of the language of the document itself, in that case a separate undertaking is to be obtained. From the borrower itself, executor of the document itself. Okay, so and also in the case of the companies where you are going to basically create a charge over the securities of the company, the charge must be registered with the ROC, that is registrar of companies also. So in case we are going to basically extend loan to the companies, and in case a charge is to be created over the assets of the company, in that case the charge must be registered with the ROC. Kindly please do let me know at the earliest, if a charge is created by way of pledge, is it required to be registered with the ROC? Kindly please do confirm the same. So if a charge is created by way of pledge, in that case, is it required so as to register the charge with the ROC? And the limitation date for registering the charge with the ROC is 30 days from the date of document execution of the document itself. And further, to confirm the same, if the charge is created related to pledge in case of company, is it required that we need to register the same charge with the ROC over there? So let me tell you, if the charge is related to pledge or lien, in that case, the charge is not required to be registered with the registrar of companies itself. Otherwise, it is required to do so. Otherwise, it is required to do so. And further, if any document is required to be registered with the sub-registrar, it should be done with prescribed time limit. So in case you're going to create a charge and further the documents are to be registered with the sub-registrar, in that case, that must be done within the prescribed time limits. That is related to the documentation part. That is related to documentation part. Then it is related to third-party guarantee. It is related to third-party guarantee. Now, what is actually the third-party guarantee? Sometimes what happens actually, let us take the case that we are going to extend a loan to the person over here, but the person A is not having that much good credibility, creditworthiness, and we want to have some additional guarantee. Now this additional guarantee will be given by some third party that is not related to person A. That is basically not related to person A as such, and which is having the credibility in the market itself. Okay, so in that case, we'll be basically taking a guarantee from third party. That is basically what? That is basically an additional guarantee that is given by some other person. Okay, so while the enterprise individual who has taken the loan, they are basically having the obligation. If we have extended a loan to person A over here, the person A is having the obligation that it has to repay the amount. But in case we want to ascertain that there will be no issues in the loan itself, and we want to basically take some separate guarantee, and in that particular case, additional guarantee can be taken by other person, and this person is basically the principal person to whom the loan has been extended, and the guarantor would be the third party. Guarantor would be the third party, which is not basically related to the loan itself, but it is extending a guarantee to the loan. It is extending a guarantee to the loan, and the liability of the guarantor is coextensive. It is coextensive, that whatsoever the guarantee is basically related to the principal, same liability basically is on the guarantor itself. Okay, so that is the third party guarantee. Further, these third parties can be individuals, or it can be any other legal entity also. It can be also any other legal entity. And in case there is finance to the firms, let us say the case that you're going to finance to the proprietorship firm. You're going to lend to the proprietorship firm over there. In that particular case where you're going to lend to the proprietorship firm over there, let me tell you, it should not be the case that you're basically allowing to extend the proprietor is person A. It should not be the case that we basically ask for the third party guarantee from person A, because already person A, being a proprietor of the proprietorship firm, is having the unlimited liability. Same case goes for the partnership firm. So let us take the case that there is a partnership firm ABC. So it should not be the case that we will be asking for separate guarantees from the partners, because already the partners are having the unlimited liability. What do you mean by unlimited liability? Unlimited liability means that whatsoever the capital which has been contributed by the partners, they are liable. That particular capital is liable, but also they are having the personal liability. They are also having the personal liability towards the obligation of the firm itself. That is said to be what? That is said to be the unlimited liability. Okay, so that case you need to understand. So if you're going to extend a loan to the partnership firm, so no third party guarantees to be taken from the partner itself. Some other party can be basically associated with the same, that we can ask for the third party guarantee from those other parties, but not from the partner, because it will be meaningless otherwise. Okay, and further, in many cases, banks stipulate personal guarantee of the promoters, directors, trustees, as they do not have unlimited liability. Now let us take the case of the public limited company. XYZ is a public limited company, and further D1, D2, D3 are the directors of the company. Now D1, D2, D3 are being the directors of the company. They are acting as an agent of the company. They are acting as what? They are acting as an agent of the company, and liability of these directors is limited. It is basically limited to the extent to the holding value of the paid up capital. Only that particular liability is with the directors only. So in that particular case, when we are going to extend loan to the XYZ firm over here, we can ask for the personal guarantee of the directors over here. So that will basically, the guarantee will make the directors personally liable for the same. That is related to it. And further, there are RBI suggestions in this particular regard. Let us have a look at it. First of all, personal guarantees personal guarantees of the directors may be helpful. It may be helpful in respect of the companies where private limited, whether it is a private limited company or a public limited company, where shares are held closely by a person or connected group of a person. So personal guarantee would be basically helpful over there. Let me give an example where we are having the public limited company or a private limited company, and for the person A in the private limited company or a public limited company, which is XYZ company, the shareholding of the person over here is 5%. Person A is having a shareholding of 5%. Now that particular person liability is over there, but also we want to make the personal A personally liable over here. In that case, we can do ask for the guarantee. That is basically the case. And also there is exception. We can do ask for what? We can do ask for guarantees in those cases also where the companies are not closely held. Where the companies are not closely held. In that case also we can also ask for the guarantees from the directors itself. Why it is required? So because we want to ensure, because in case of the company, actually what is the criteria? Let me tell you that here are the shareholders. Here are the shareholders, which I am basically indicating by way of arrows over here, and the shareholders are the owner of the company. These are the owner of the company, and for the directors are those who does manage the management of the company. And also if you want a company to achieve the corporate objectives, and for the management part is also very much crucial. The management part is also very much crucial. And if we want to ensure that there will be continuity of the current management itself, we can take the personal guarantees of the directors also. We can take the personal guarantees of the directors also. Okay, so that is a case that we can do ask for the guarantees of the directors too. Okay. And further, there is an exception. What it says, the exception being in respect of the companies where by court or statutory order the management of the company is vested in a person or persons over there. So Reserve Bank of India is having broader powers. The Reserve Bank of India is having broader powers under which the management of any banking company, and also there are many legal aspects. Under which the management of the companies can be basically vested with the person or a group of persons. So if we say that the company XYZ is over here, and previously they were having the management M1, and now it is legally replaced by M2 over here. It is legally replaced by M2 over here. Now over here, this particular previous management was basically elected by the shareholders, because the management is basically elected by the shareholders who are the owners of the company. Okay, but now this M2 is basically vested in the power of the management over there, because this is appointed by the court or some statutory order. And further, in that particular case, there is exception that the guarantee cannot be taken from that management. Guarantee cannot be taken from that management over there. Is that clear? Is that particular part clear over here? Second, it says even if company is not closely held. I just told you already, even if the company is not closely held, because we want the continuity of the management over there, we can do go for the guarantee from the management itself. We can do go for the personal guarantee of the directors, so as to ensure the continuity of the management. So as to ensure the continuity of the management over there. Is that clear? Further, one way by which lending institutions could protect themselves in such circumstances is to obtain the guarantee of the directors, because whenever we do lending to the companies over there, we are more concerned about when the management will be changed, how they will be acting, and how the functionaries will be performing. Okay, so if we want to ensure ourselves that there will be continuity of the management, definitely we can go and ask for the personal guarantees of the directors. Okay, so as to ensure the continuity of the management over there. Is that clear? Further, the third point, it is related to personal guarantee of the directors may be helpful with regard of the public limited companies other than those which may be rated as first class, where the advance is on unsecured basis. So wherever you are extending unsecured advances and further it is not rated well, definitely the bank must be asking for the personal guarantees of the directors. And further, whether the companies are public limited companies whose financial position and cash generation is not satisfactory, even though relevant advances are secured, if the relevant advances are secured, the bank can do ask for the personal guarantees of the directors. That would be useful itself. Why that will be useful? Because there is basically not satisfactory repaying capacity of the organization itself. So as to make it ensure ensure that the company will be repaying in time, the personal guarantee of the directors is very much required in that particular case. And for the cases where there is likely to be considerable delay in the creation of the charge of the assets, and also it is the case now, whenever a loan is extended, let us say the case to XYZ company, loan is extended over there and a charge is to be created and a charge on the asset of the company is to be created. I just told you that this particular charge is to be registered with the ROC, that is with the registrar of companies over there. And there can be a delay because there is a time stipulation that the charge can be registered within a time period of 30 days. I just cleared that there is basically a stipulation that a charge basically registered with the that basically when you basically register a charge on the assets of the company, that must be registered with the registrar of the companies within a stipulated time period of the 30 days over there, and there can be delay. So as to cover this interim period, that when the charge is not registered with the ROC over there, you can do ask for the same. You can do ask for the personal guarantee of the directors over there. Okay. Further, the guarantee of the parent companies may be obtained in case of subsidiary whose own financial conditions is not considered satisfactory. So where you are having a group of companies, and further here we are having the parent company, and here we are having the child companies or the subsidiary companies over here, and in that case the current situation over here, if the current situation of the companies or the subsidiary companies over here is not satisfactory, definitely we can do ask for the personal guarantee by the parent companies over there. Personal guarantees are relevant where balance sheet or financial statements of the firm discloses interlocking of the fund. If there is interlocking of funds, what do you mean by interlocking of funds? Where the funds are basically diverged between the different subsidiaries of the same group of the companies over there. In that case also we can do ask for the personal guarantee of the group of the companies over there. Is that clear?